Hi everybody. Welcome to today's webinar on the SeedFast series on the process and milestones of a financing round. Today, we are celebrating the fourth webinar in this series held in English. We started the series with an overview. Let me show you which one. Yeah, exactly. We started the series with an overview of the individual steps of a financing round and showed the slide with the timeline that you can see right now. In the second webinar of this series, as you can see on that slide, we presented the individual forms of capital increases, and the last time we focused on the term sheet and the term sheet negotiations. We will publish those slides and the recordings of those webinars on the LinkedIn pages of Lex Futura and Konsento, and we will also make them available on the SeedFast website. Therefore, please follow us regularly. We highly recommend to do so. Subscribe to our LinkedIn pages and learn more about financing rounds and what's in for you. Today, we will focus on the due diligence of a financing round, or more precisely, on the legal due diligence. A financing round is also associated with major challenges, but I think that one of the biggest thrills of the legal due diligence is the legal due diligence by the potential investors. Because in this phase, the startup receives a ruthless, critical assessment from the outside, which decides whether the investors continue with the startup in the financing round or turn their backs to the startup. That's why preparation for this is all the more important. And that's what today's session is all about. Alain Friedrich from Lex Futura will explain to you why this is partly responsible for the successful conclusion of a financing round and what founders need to pay attention to. But now I would like to hand over to Alain, who introduces us to the secrets of a legal due diligence. Please, Alain.
Thank you, Dominik. Very warm welcome from my side as well. So as Dominik said, last time we talked about the term sheet and how a term sheet kicks off the entire financing round. Today, we're looking at the next step in a financing round, the due diligence or the investor due diligence. We talk about what a due diligence actually is, what documents you need to disclose, and some examples of potential issues in a due diligence. Let's dive in. First, what is a due diligence? What do we actually mean? Well, basically, it's a structured health check of your company. The investors want to fully understand what they're investing in. So they don't invest in a black box. They want to know what the risks are. First, it's basically a comprehensive risk assessment. That includes legal, tax, operational, financial, often also technical due diligence. Not every area is very relevant for every company, but investors know what to focus on. In a company that basically lives off IP, the IP due diligence is very important. Sometimes regulatory due diligence is important for a company that operates in an area where regulatory supervision is very important. Second, the due diligence reduces information asymmetry. Founders, they know the companies inside out. Investors don't. So due diligence helps the investor to understand the company a bit better. Usually they have a pitch deck. You presented them a pitch deck, but they don't really know who are the employees, what are the salaries, is the company over-indebted, is the IP with the company, or is the IP with your freelancer in Thailand or somewhere else? It's quite important to get an understanding of the company. Then it's tailored. Every investor usually focuses on a few different verticals and knows where the risks lie. Again, we often work with tech companies, and there the IP is very important. But if you go into a SaaS business, for example, IP is important, but also the contracts with your customers. Due diligence, particularly in a pre-seed or a seed financing round, is very tailored. The investors want to know a bit more about certain risks in certain sectors. And then in the end, it basically forms the foundation of the transaction. The term sheet is here for the contractual arrangement, but the due diligence often reveals results that are then incorporated into the investment agreement in the so-called representations and warranties. We get back to that later. How does due diligence actually happen? 10, 20, 30 years ago, it was a physical exercise. You had to go into a physical data room and go through all the folders. Today, it is digital. Either you have a very simple solution via Microsoft Teams or Google Drive. If you're a bit more sophisticated, you use a special data room provider, but it's all digital and you have to upload your files to the digital data room. So what documents are necessary for a legal due diligence? Usually you get a so-called document request list from the investor. The investor tells you what documents you need. These documents usually include corporate documents, the articles of association, the share register, all shareholder and board resolutions. So bear in mind, please do shareholder and board resolutions, all documents related to capital increases, all documents related to your ESOP, then all material agreements, be it the shareholders agreement you have among the shareholders, but also with your customers, potential outstanding convertible loan agreements, employment agreements, bonus plans, IP assignment agreements with your developers inside your company or outside, the business plan, financials. You often also have to upload the financial statement and then disclose this as well. So as you can see, quite a lot of documents need to be disclosed. That's why it's a good idea to start the due diligence exercise early or be prepared and organized. The best thing would be to basically have a clear folder structure where you upload all the documents as of the incorporation of the company, because then you don't really have a lot of stuff to do once you actually open the data room to the investors. So one thing I wanted to share with you is some examples of potential due diligence issues. One thing that often comes up is an IP ownership gap. Basically, as a company or as a company that attracts investors, the company needs to have the IP. You often see that companies work with employees or consultants, but they don't really have a valid or sometimes not even a IP assignment clause. So usually this is when the investor asks the company to get an approval of all the previous and current consultants to sign an IP assignment contract. And this is basically a closing condition for the investment. One classical example is a domain registration. You'd be amazed how many companies still have their domain registered in the founder's private account. That's a problem. And that's something the investors look at. That's why you always have to make sure that your domain name is registered with your company and not your founder. Then employment contracts. Overtime compensation is something that is quite important when investors do a due diligence of employment agreements, because in a startup, you often work crazy hours. And if it's not clearly stated that overtime is compensated with the base salary, then this exposes the company to quite a lot of risks. So it's important to have proper employment agreements here as well, because the investor does not want to pay someone that leaves the company overtime compensation with his or her investment that actually should be used for the company to build the product. And then if you have obviously subsidiaries in Switzerland or abroad, then a special due diligence takes place. When you talk about due diligence, it's also important to talk about disclosure systems and how the legal DD affects the agreements. So how does due diligence connect to your investment agreement? The answer is basically through disclosure. The idea here is in the investment agreement, there are a few representations and warranties. Maybe Dominik, can you go to the next slide? Representation and warranties. Things like, we own all of your IP, we've issued 1 million shares, we don't have any options outstanding, there are no ongoing disputes, stuff like this. Sometimes this is not true or not 100% accurate. That's where the disclosure systems come in. There are basically two approaches. First is a disclosure via the data room, or reps and warranties against the data room. This is a common approach in Switzerland and most of Europe. It means basically if something is uploaded to the data room, it's considered disclosed. That means an investor is aware of it. So if the investment agreement states the company has 1 million shares outstanding and you have a document, the current articles of association, which clearly shows that the company has 1,200,000 shares outstanding, then the investor knows that it's not 1 million, it's 1,200,000. This is a system that is quite easy and in favor of the founder. Because if you upload something to the data room, it's considered disclosed and you're basically safe. Disclosure via a disclosure letter or disclosure schedule is a bit different. Here, even though you have a data room, you have to go through the entire list of representation and warranties and explicitly state the exceptions. So at the moment, I'm working on a deal where it's quite cumbersome, where we have to list, for example, all material agreements that are agreements that have a contract value above 50,000 Swiss francs. This is a lot of work, even though these agreements are disclosed in the data room or uploaded to the data room. In this particular case, it's not considered disclosed, and we have to make a proper list with the contract parties, the contract volume, etc. So you really have to understand that uploading to the data room is not automatically being disclosed. You have to look at your agreements and check whether you have representation and warranties against the data room or disclosure letter against the data room. So now you understand a little bit what was important when we talk about due diligence. And to disclose as many things as possible and take your time when working through the disclosure schedule is very important. So let's bring it all together. Due diligence is not just a formality. It's basically a critical part of the investment process. It helps both sides to build trust and uncover certain issues. And you also get to know the investor. As a founder, it's also basically a chance, as a startup, it's a chance to show the investors we are organized and we are transparent. So if you have a well-organized data room from the beginning, it's quite a large asset. And also from a legal perspective, it's your best protection to clearly document and upload all the agreements you have. If you're ever in doubt, you need to disclose. It's always better to be upfront with something than to leave it out and risk it becoming a huge issue later. So this, Dominik, is a short wrap-up about due diligence. Are there any questions?
Yes, thank you very much for the explanations. And yes, we do have questions. The first one refers to the data room that you mentioned. You said there are different types of data rooms. You can do it in Microsoft Teams, but you can also do it in dedicated solutions. So the question is, what drives that decision? Is it really necessary to track what investors did? So how long they spent on each document or where they scrolled to in the document?
So my general recommendation here is in pre-seed and seed rounds, it's perfectly fine to just use Google Drive or Microsoft folder. And because the amount of documents is limited and the legal risks are usually also limited. The only downside is usually you cannot export a list of all documents. If you do a disclosure against the data room, then that means that you have to have an index of the data room somewhere. And with a professional data room software, you can automatically print this list. If you don't do this, you have to do it manually or use some AI solution to basically have an index. But it's totally fine, and it's actually also very commonly accepted by investors. If you do an M&A transaction or a later financing round where the amount of documents is quite large, it's good to have a professional provider, because then you often have to refer to certain documents. And if there are 100 documents in there, professional softwares, they automatically number the documents, so it's much easier with that. But I think if with pre-seed and seed rounds, it's totally fine to use a cheap option.
Okay, thank you. Then there's another one. You mentioned the disclosure letter. Is this the same thing as an NDA?
No, an NDA is basically a confidentiality agreement. So two parties or more parties agree we keep this confidential. A disclosure letter is a letter where the company lists all exceptions of the representation and warranties. For example, in the representation and warranties states the company is not party to any dispute. And then you have a small employment relationship proceeding with one of your employees. You write in the disclosure letter, disclosure against the rep and warranty number X. The company is currently in employment law proceedings with employee X. The amount is Y. So the investor knows, hey, they are a part or party to a proceeding. So basically, have to inform the investor, even though you might have uploaded the relevant court documentation to the data room.
Okay, good. Thank you very much for your explanations. This is it with the questions, and therefore I would like to draw your attention to the next webinar we're having. This will be on the 30th of April, again at 11 a.m. to 11:15 a.m. And more interesting is the topic than the time. The topic will be the investment agreement, the basics, what founders need to know. So again, here we learn what are the cornerstones of an investment agreement and what is in for you. So thank you very much for your attention. Thank you very much, Alain.
Thank you, Dominik. See you guys
in 2 weeks.
later.
Bye-bye.